Hi, I'm Susan Duncobb, bringing you the news you really need to hear. At the moment, no child is safe, and we are going to change that. Our top story is a Megan Walsh kidnapping in retaliation for her expose of the criminal agency involved with the global child sex trafficking cartel that her father was instrumental in establishing. I could do my whole news show on this story alone, but I will attempt to hit the high marks. For an in-depth knowledge of what we have learned about National Center for Missing and Exploited Children, please see the video special edition, Megan Walsh Kidnapping Chronicles, June 2022, also on my channel. This is an ongoing and developing situation. Megan Walsh is the daughter of John Walsh of America's Most Wanted TV show that most of America, myself included, loved to watch every week when it came on. It lasted for many years. Because of the disappearance of one little boy, John and Reve's son, Adam, a worldwide organization was created and developed to track and find missing children. It now has every child in civilized nations placed into its database. With this database accessible to all nations, all police forces, all child protection agencies, and all courts, they now have the ability to follow any child from birth to maturity or death. What sounded good in concept has become an underground railroad of trafficking. Children are removed from loving parents by child sex traffickers using the child protection systems throughout the globe. Parents have no recourse, no rights, and never see those children again. Children can run away from their new foster homes, even if they are too young to run, and after 6 months of being missing, they are removed from the child protective case records. All records are computerized. Missing and lost children in foster care are never looked for and never put on the Amber Alert system. You may make any conclusions you like about that. They will undoubtedly be correct. About 2 years or so ago, Megan, John's daughter, began asking questions. She is a smart lady. She has excelled in more than a few business pursuits and accomplished much for her young age. She did research on her own, began to stop making excuses for the abuse she'd been raised up with, and learned many things she never wanted to know. Then she told. She has love for her parents, but they are desperately seeking any way to do damage control for what young Megan has revealed. The retaliation is brutal. John, her father, had her 3 children kidnapped, her home taken from her, her finances blocked, and he is now attempting a Britney Spears type of conservatorship. At some point in this, Megan, brokenhearted, was contacted by her long-lost brother, Adam, who had tried but failed to reconnect with his family. His story is riveting, and I posted it on that special edition, Megan Walsh. And you can also find it on Punished for Protecting YouTube channel. It's titled, Is This Adam Walsh? Megan, pregnant at the time her children were kidnapped by Dad, found a place to stay for several months. She thought the lady was kind and was a friend. But immediately after the birth of the baby in that home, Cops surrounded the house and kidnapped that baby. John and Reve didn't want that one, however, so baby Esther went into foster care. That kidnapping video is one everyone should watch. It is exactly how they will come to take anyone's child. Megan was physically threatened and thrown out of that friend's house suddenly, a very short time after the kidnapping. She now does interviews and is struggling to do the impossible in an attempt to regain custody of her children and keep her freedom. Daddy is mad. She told, and she is still telling. I hope you watch the special, and I hope you get to see Adam as he reveals his story. I will be following this one closely. My second story, ABC News' Katie LaGrone publishes a lawsuit involving the truth of the horror that parents deal with when their children are literally stolen by the state and sold into slavery. It's happening all over Florida, said attorney Octavia Brown of Community Law for Families and Children. She's part of a team of attorneys who filed the complaint. When LaGrone suggested the lawsuit accused kidnapping by and within the system, Brown responded, "Well, what else do you call it? If there is someone who's connected to the system and they see a child that they want, they're going to get the child." Brown is also a former insider who worked as an attorney for DCF, that's CPS in Florida, and other agencies representing Florida's foster care system. This was an excellent report, and I'm very grateful they report on it. That is rare. I'm sharing and posting a clip from Ivory Hecker as to how rare it really is. But I'm posting a news piece that I highly recommend everyone view. It describes how child protection industry lies against parents in court, how the medical establishment does the same, and how very capable relatives are never given the child because then the state loses the federal money for taking them. Florida now has over 21,000 children in custody, and they are no worse than the other 49 states. There's easy money to be had, and the village is hungry for more kids. I also want to add that I find it very surprising that ABC covered this story. Ohio City and County prosecutor caught driving naked 5 times was suspended by Ohio Supreme Court. Well, I'd say this is probably good news. This came to me from Shannon Henderson and Catherine Wang Anderson, Newsweek and WLWT Channel 5. On Thursday, the Ohio Supreme Court indefinitely suspended Scott Blauvelt, a 50-year-old attorney who received his law license in 1997, according to the court opinion. Blauvelt has served as a prosecutor for the city of Hamilton and an assistant prosecutor for Butler County. Police caught the lawyer driving naked 5 times between 2018 and 2021, the Supreme Court showed. A previous opinion was noted that in 2006, when Blauvelt was the Hamilton city prosecutor, security cameras captured him naked after hours in the government building that housed the prosecutor's office. Although his public indecency charge at the time was dismissed on a speedy trial violation, the city fired him. Good for that, right? In May 2021, Blauvelt started a 2-year program to treat compulsive sexual behavior disorder. He attends weekly psychotherapy sessions as well as meetings for Sex and Love Addicts Anonymous, a 12-set program for sexual addiction. He also sees a psychiatrist for his diagnosed bipolar disorder. He liked to walk around the city building nude and was caught on more than one occasion. He was eventually fired and had his law license suspended. Perhaps you can appreciate why this is good news for all of us. These are some of the people in our neighborhood and who also have been given authority over us. Got this one from Shannon and Catherine. WBRC Channel 6 reports, a federal grand jury indictment was unsealed charging a Birmingham lawyer, Chase Espy, with child exploitation offenses, announced U.S. Attorney Prim F. Escalona and Federal Bureau of Investigation Special Agent in charge Johnny Sharp Jr. The two-count indictment filed in U.S. District Court charges Chase Tristan Espy, 36, with attempted coercion and enticement of a minor and possession of child pornography. Prosecutors said the charges involve events that occurred from March 2021 to August 2021. Why is this news, you might ask? Espy is a former member of Alabama Governor Kay Ivey's staff. This comes from Catherine Anderson and American News. June 17. A teacher from Hawaii admitted to recording himself having sex with a 13-year-old student and sharing the footage, along with hundreds of other images and videos depicting child pornography. Alden Bunag remains in custody. Bunag admitted that he had been sharing child pornography with a teacher in Philadelphia, according to KHON. He and the other teacher, who was arrested in October, exchanged more than 3,300 messages, hundreds of which contained images and videos of child pornography. Bunag also admitted to having sex with a 13-year-old student at the school during lunch breaks. Recording and sending the content to others. Court documents show he knew that the boy was underage at the time. You think? Bunag described himself on Twitter as a socialist high school teacher fighting for a better society. Shannon Henderson and Catherine Wang Anderson sent this from the LA Times. Dr. Bruce Hansel, who had long served as NBC's chief on-air medical correspondent in New York and Los Angeles, repeatedly texted a 9-year-old girl from March to August of 2019, at some points asking her for photos that were sexy and private, according to records submitted to the California Medical Board earlier this year. Eventually, Hensel told the girl to take pictures in underwear or less to secure her place in a movie, according to the medical board records. That same night, the 9-year-old took several nude photographs for the NBC star, according to those records. Hensel was arrested in November 2019 on suspicion of communicating with a minor for a sexual purpose and faces up to 18 months in prison if convicted. In the years since, Hensel has sought a plea deal that would allow him to avoid registering as a sex offender. Hensel was arrested in 2019 but remains out of custody awaiting trial. His license to practice medicine was suspended when the charges were filed. Now here is the real story. Consider the lives of the people offered to us on our ballots when we elect them. Former LA County District Attorney Steve Cooley has become an unlikely ally of Dr. Hensel, who over the last year has emerged as one of the leading voices in the movement to recall current District Attorney George Gascon. The recall movement, which now seems to have a chance to collect enough signatures to force Gascon into a recall election, has largely been animated by the idea that the district attorney's policies are harmful to crime victims. Remember that part. They are wanting to recall Gascon because he's presumably soft on crime. Cooley confirmed he was hired by Dr. Hensel's defense team to consult on a district attorney's office policy he previously authored about the collateral consequences of sentencing decisions, which, if applied in Hensel's case, would have affected whether the doctor had to register as a sex offender. In Hensel's case, registering as a sex offender would bar him from practicing medicine or teaching for the rest of his life. He's 72, by the way. He's an old enough man to clearly know what he was doing and what he was risking. Jamara Hayner, who is managing Gasson's anti-recall campaign, said Cooley's decision to aid someone accused of a sex crime involving a child called into question his claims to be a crusader for crime victims. You think? Mr. Cooley's opinion on who deserves punishment and who deserves protection seems to oscillate conveniently based on political opportunity and what one can only assume are staggering consultant fees, she said. Cooley is one of several current and former prosecutors rumored to be considering a run to replace Gasson if the latest recall attempt qualifies for the ballot. Who really are the people in your neighborhood? It's way past time for people of integrity to run for office. Is it you? Shannon and Catherine shared the CBS News story of a program director at Sarah Hines' house who has been arrested for child sex crimes. Nicholas Gendel of Pittsburgh, Pennsylvania, is accused of sexually assaulting a 6-year-old. His mom says she found Gendel on the website care.com because she needed a babysitter. He worked at the youth organization Sarah Hines' House on the North Side as the education program director before he was arrested and let go. Court documents show Gendel's bail was denied, stating that he's a safety risk to the community. Investigators say they were contacted at the end of May about the alleged sexual abuse of a 6-year-old boy. The boy told police he was abused by Gendel, his babysitter. The child's mom told KDKA over the phone she hired Gendel through the website care.com a little more than a year ago and says he occasionally babysat her son. She says he also babysat for other families. I feel like I can't be the only one and encourage other parents to ask their kids about Nicholas Gendel and come forward, she said. She said what's most disturbing is she paid a premium to get extra background checks done through the website and trusted he'd be a good sitter given his status at Sarah Hines' House, which is a member of the Boys and Girls Club of America. Sarah Hines' House says all employees must undergo a comprehensive background check prior to being hired, as well as annually. Pittsburgh police are still actively investigating and encourage anyone who has concerns to give them a call at 412-323-7141. Shannon Henderson sent this from complex.com. June 10th. A teacher at a private Christian school was arrested this week after she allegedly sent sexually explicit text messages to one of her students. According to WCTV, 38-year-old Julie Hoover, an educator at Point of Grace Christian School in Perry, Florida, was taken into custody Wednesday and hit with one count of an authority figure soliciting or engaging in sex with a student. The outlet reports the alleged victim was an 18-year-old who was enrolled in several classes taught by Hoover. An arrest report states the mother contacted the local sheriff's office on June the 2nd, claiming she discovered an explicit text conversation between her child and Hoover. She said one of the topics included Hoover's plan to sneak the student into her home while her husband was away at work. Investigators say the text messages in question were sent in March and April. This is from Michael Volpe, sent to Facebook group Action Law Family Law Project. It involves an international custody dispute. Narcus Golan is a U.S. citizen who is living in Italy with her son. Her ex-husband, Isako Golan, and his family are from Italy. She went on a trip to New York City with her son and decided not to return. Why? It's because her ex-husband was abusive. Below is a link that shows the example of the abuse. Trigger warning if you watch this. It's a perfect example of what so many women go through. If this is done to someone, they should leave while they can. She went into a shelter and her husband filed for return of his child. Despite the abuse, Narcus ran into international law under the Hague Convention on the civil aspects of international child abduction. Appeals court ordered her to return to Italy. Short story to what happened is months of courts going back and forth. The U.S. Supreme Court reversed course. The boy, at the heart of a custody dispute between his American mother and Italian father, won't have to be returned to Italy just yet. After the U.S. Supreme Court sided with the woman over what's required under an international treaty. In the unanimous ruling, Justice Sonia Sotomayor clarified that federal courts are not required to consider all possible ameliorative measures when refusing to return a child to their home country because it would put them at risk of physical or psychological abuse. I'm going to add to this by saying this isn't over. But this decision will have a great effect on how these issues will be handled in the future. It is an important case, since it appears protective on behalf of women who cannot physically defend themselves or their children against a stronger enemy. Then I'm going to call it good news. This comes from Catherine Anderson and the New York Post. Tor Eklund, a Brooklyn criminal defense attorney, sues New York City cops after arrest for destroying son's laptop. June 18th, Tor Eklund, 52, says his constitutional and civil rights were violated when two detectives charged him with criminal mischief for the January 2021 incident in which his 13-year-old son allegedly lied about doing homework on the device, prompting the angry dad to throw it on the ground and stomp on it, according to a lawsuit. The divorced father of two, who had bought the laptop for the boy, spent $7,000 on tutors and substantial time with his son to help him with school, he said in a Brooklyn federal court lawsuit against the NYPD detectives who arrested him, Palaka Benz and Edwin Exelom. He was arrested in March 2021 on a criminal mischief charge after his ex-wife called cops 2 weeks after the incident. The officers refused to give him a desk appearance ticket, which would have allowed Eklund to return to court at a later date, he said in the litigation. He wound up spending 26 hours in a holding cell at Brooklyn Criminal Court awaiting arraignment. By July, the case was dismissed, he said. The detectives were recklessly and deliberately indifferent to the truth and had no probable cause to arrest him, insists Eklund, who is seeking unspecified damages. The arrest was an injustice And Eklund looks forward to his day in court. Remember, this is a criminal attorney they decided to do this to. Attorney Philip C. Hamilton said, "For any parent familiar with raising teenagers in this era of excessive screen time, what happened to Mr. Eklund is an absolute travesty that should never happen in a society that fundamentally honors values and respects parental rights," Hamilton added. I'm going to have to just throw one in there and say, he doesn't have a clue about parental rights. That's in his imagination. They don't exist right now. But we're getting them. Whatever you think about the way he disciplined his son, consider the fact that you can go to jail for just about any arbitrary method the state doesn't approve of, which you choose to use in raising your child. You better keep up with the latest and what's okay with Big Brother, because the rules are changing rapidly. My question to you is, whose child really is it? The state acts on the presumption it's not yours. Catherine Wang Anderson posted this. The Seventh Circuit Court of Appeals has dismissed a class action lawsuit demanding sweeping changes to Indiana's child welfare system. The suit alleged the state, via the Department of Child Services, violated the children's due process rights, their First, Ninth, and 14th Amendment rights, the Adoption Assistance and Child Welfare Act of 1980, and the American with Disabilities Act and Rehabilitation Act. More broadly, the plaintiffs alleged Indiana's child welfare system inflicts further trauma upon an already vulnerable population. Here's a wiggle out part. Their conclusion, basically. It is improper for a federal court to issue an injunction requiring a state official to comply with state law. Indiana's foster care system has high levels of removals and court involvement, which in turn causes high caseloads and turnover rates. The plaintiffs sought sweeping changes to DCS practices and policies, including requiring DCS to maintain caseload standards and that its verification process be public information instead of the secret stuff. Requiring the agency to conduct an annual case review to ensure children are receiving timely permanence and the degree of maltreatment, and to make these reviews public information instead of secret stuff. Preventing the separation of siblings when they enter the child welfare system unless it is contrary to the best interests of any of the children to be placed together with his or her siblings. Preventing a child's placement in a congregate facility due to a lack of available foster homes. Taking all steps possible to ensure a child is placed in a safe, adequate foster home, and if necessary, to find an appropriate adoptive placement. We are disappointed in the decision by the Federal Appeals Court, which leaves children in foster care in Indiana without access to the federal court to enforce their constitutional and federal rights, a right that is available in many other parts of the country, Lowry said in a written statement. Unfortunately, the court's decision did not adequately address our arguments. Given the status of the child welfare system in Indiana, this right is particularly critical. According to data provided by DCS, Indiana had over 10,000 children in out-of-home placements in April 2022. So, there is no remedy through the state courts, no remedy through the federal courts, no ADA protection, that's a farce, no parental rights protection, no rights to your children. And it isn't just Indiana. 49 other states are the same. If we can't protect our own children, we no longer exist as a free nation, but we are an enslaved people group who breed and work for our captors, nothing else. According to data provided by DCS, Indiana had over 10,000 children in out-of-home placements in April 2022. I will add every one of those bringing in lots of money under Title 4E. Also, in Minnesota, 4,000 parents joined a lawsuit for the same thing, kidnapping their kids with CPS or DCS or whatever the initials are. It was dismissed. No legal standing. But Alaska's going to try next. Class action lawsuit calls for major reform in Alaska's failing, dangerous foster care system. Could be every state. Alaska's child welfare system is failing, dangerous, and routinely violates the rights of children, asserts a first-of-its-kind class action lawsuit filed against the State Office of Children's Services in federal court Thursday. Go team, go. The 90-page complaint alleges that systemic issues have long festered in almost every facet of Alaska's child welfare system and asks a federal judge to order immediate and sweeping changes. There has not in Alaska been a comprehensive lawsuit on this subject until now, said Mark Regan, an attorney with the Disability Law Center of Alaska, one of the entities representing the plaintiffs. The state of Alaska has long known about the magnitude of the problems in its child welfare system, but hasn't acted to fix them, the lawsuit alleges. Yeah. And so now they will, right? I have faith, but not in these things. But more power to them. And every time they're turned down, no jurisdiction, not my problem, don't come here, don't bother us with your little constitutional issues. Every time that happens, they help us build a bigger case against them. We are the people that they serve. They become tyrants, they steal our children. They need to get fired. June 13th, the Heritage Foundation published an extensive report by Jay Green regarding puberty blockers, cross-sex hormones, and youth suicide. The link I'm posting will enable you to study actual facts and science, refuting purported propaganda currently filling our airwaves regarding the push to castrate our youth in their childhood. Because that's what it is. If you need any backup for your convictions, this will provide you with much. This is a summary. Lowering legal barriers to make it easier for minors to undergo cross-sex medical interventions without parental consent does not reduce suicide rates. In fact, it likely leads to higher rates of suicide among young people in states that adopt these changes. States should instead adopt parental bills of rights that affirm the fact that parents have primary responsibility for their children's education and health, and that require school officials and health professionals to receive permission from parents before administering health services, including medication and gender-affirming counseling to children under 18. States should also tighten the criteria for receiving cross-sex treatments, including raising the minimum eligibility age. The key takeaways? Number one, U.S. policymakers are seeking to make it easier for minors to access puberty blockers and cross-sex hormones based on the claim that doing so reduces suicide risk. Number two, studies finding that gender-affirming interventions prevent suicide fail to show a causal relationship and have been poorly executed. Those studies were not good studies. Number three, a superior research design shows that easing access to puberty blockers and cross-sex hormones by minors without parental consent increases suicide rates. We could have guessed that, right? Here's another "Who Are We Really Voting For" story sent from Shannon Henderson. June 16th. The Alabama Political Reporter states the now adult son of Sabrina Martin, an unopposed Democratic nominee for family court judge in Montgomery, has come forward with his own recounting of what life was like in her home between 2010 and 2012. He had been adopted by the judge. It was Jesse Heifner, Sabrina Martin's then boyfriend and now husband, that had done the whipping of Jonathan that had caused the bruising, Jonathan said. He would hit me with all his force, man, Jonathan said. According to Jonathan, Sabrina encouraged Hefner to engage in punishment. Jonathan Martin, now 21, joins his sisters Jasmine and Sydney in detailing allegations of excessive corporal punishment that resulted in an Indiana court removing 6 children from Sabrina Martin's care in 2013. Jonathan reached out to APR following the publication of Thursday's article wanting to recount his childhood. It felt like a bad story. It didn't feel real, Jonathan said. It felt like there was no escaping it. The link I posted has detailed tortures this judge wannabe did. I am skipping the sordid details. You may read them. When my dad finally got custody, everything felt fake for like 3 months, Jonathan said. It felt like he saved me. He felt like Superman in that case. Some of his family was aware that Sabrina Martin was still in Montgomery practicing family law and even working her way up to run for family court judge. So, this mother who wants to be family court judge denies everything. Another judge story. Judge seeks re-election, suicide attempted. I'm reading from the Patriot Punk Network, who reports June 9th. Judge Amy Hollers is seeking re-election in the 13th Judicial District for Circuit Court Judge. In early February 2022, in the wee hours of the morning, a Mr. Bob Burns made a 911 call. During this call, Mr. Burns alerted the dispatcher to a situation involving his wife, Amy Hollers. My name is Bob Burns, and my wife has taken too much Xanax and too much alcohol in, I think, about a half-hearted suicide attempt. I need somebody to come and get her. Mr. Burns goes on to say that he believes Hollers consumed approximately 30 milligrams of Xanax and about half a bottle, I figure, of vodka. Thankfully, dispatch reacted quickly, and Judge Hollers appears to have made a full recovery. We have reached out to Hollers to check on her well-being and ask if she's getting the professional help she needs. But at the time of this publication, we had not received a response. I'm reading directly from the article. As a sitting judge over the 13th Judicial District's Circuit Court, Hollers oversees both civil and criminal cases of all types. Could a mental health crisis affect the decisions made by a sitting judge? If a sitting judge is misusing prescription medication, should they oversee cases involving prescription drugs? If someone is on high doses of a drug like Xanax, which is often used to cope with anxiety among other mental illnesses, and known to cause memory blackouts, could that affect their judgments from the bench? These are good questions. Suicide attempts are not something that usually come out of nowhere, and the caller seems fairly calm on the phone, considering the situation. Is this the first time this has happened? Is there a history of self-medication? Who is the other voice in the background of the call? And lastly, how many rulings could be in jeopardy due to these issues? Hollers has sat on the bench since 2008 when she was appointed by Governor Phil Bredesen to fill a vacancy left by her father. The 911 audio was posted on the link for viewers to listen to. My thoughts are, she's up for re-election, folks. People in authority should be thoroughly researched before you go to vote, don't you think? Shannon Henderson sent this June 12th, ABC 15. Arizona reports local defense attorneys say former head of the Arizona Department of Corrections, Charles Ryan, is facing reduced charges involving an armed confrontation with police compared to other defendants in similar cases. Favoritism? No, they wouldn't do that, would they? The ABC 15 investigators looked at dozens of cases assigned to the now disbanded First Responders Bureau, which prosecuted cases where officers were victims in 2020 and 2021. ABC 15 focused on 3 cases. All 3 men had guns in their possession when police arrived on scene. All 3 were indicted by a Maricopa County grand jury. None of the cases involved physical injuries to officers. However, the charges in Ryan's case diverged from the other 2. Charles Ryan was charged with 1 count of unlawful discharge of a weapon for allegedly firing a gun in his home before police arrived. He also faces 1 count of disorderly conduct involving weapons for allegedly pointing a gun at officers assembled in front of his home. Both are Class 6 dangerous felonies, which are low-level felony offenses punishable by about 2 years in prison. The 2 men in the comparative cases were charged with aggravated assault with a deadly weapon. These are Class 2 dangerous felony charges because police officers are listed as the victims. The sentence for this offense can be 10 years or more in prison. Ryan is a retired director of the Arizona Department of Corrections. The article I've posted a link to is very detailed in the comparisons of the 3 cases to show the obvious favoritism given this man. What is the process? Well, when the Maricopa County Attorney's Office took the Ryan case to the grand jury in April 2022, Ryan's indictment came back without aggravated assault charges. It's a one-sided story presented in secret, said of the grand jury process. Nobody knows what evidence is presented until that transcript is released only to the defense attorney. It's a very, very secret proceeding. Ryan is expected to plead not guilty at his arraignment later this month. This is another example. The rules are for thee, but not for me. Shannon sent me this June 11th. NYNBC reported in February 2022 from Mobile County, Alabama. WPMI, a mobile police officer is under investigation tonight. MPD Internal Affairs and the city's Office of Professional Responsibility are looking into claims Officer Robert Harris had an improper relationship with a minor. A department spokesman tells NBC 15 investigators will turn over its findings to the district attorney's office. Harris is on desk duty while the investigation is underway. But there's more to the story. Mobile Police Corporal Raymond Grissett was driving home in his department-issued vehicle, traveling northbound on Highway 43 near John Johnston Road in McIntosh, Alabama. He observed a male subject, later identified as Robert Harris, that's our guy, in the roadway and attempted to change lanes when the subject intentionally struck his vehicle. This is the cop car, right? Corporal Grissett turned around to investigate and was assisted by a McIntosh officer who was responding to the location involving the same subject. Harris was acting erratic and combative while making suicidal statements and refused officers' repeated commands. Harris continued to demand the officer to take his life and produce an object from behind his back as if it were a weapon. The McIntosh officer deployed his taser, which had no effect. Corporal Grissett then fired his weapon twice but did not strike Harris. Harris fled from the officers, hurling himself into an uninvolved passing vehicle. Harris then gained access to his vehicle, at which time he attempted to flee. Officers pursued and deflected Harris's intended direction, which resulted in him colliding into the convenience store, where he was taken into custody. Robert Harris is no longer employed by the City of Mobile Police Department. He resigned on March 30, 2022, while under administrative and criminal investigation. Harris resigned before the conclusion of his administrative investigation into allegations of conduct unbecoming and unlawful conduct in reference to contact with a juvenile. But there is still more to the story. June 16th, the Washington County Sheriff's Office confirmed that an inmate, former Officer Robert Harris, has died in the county jail. Very sad. The moral of this story is, don't mess with kids in the first place. I discovered this from Catherine Wang Anderson. The Daily Mail reported June 29. Female cop 31 is jailed for 20 years for sexually assaulting two teen boys, 16 and 15, after grooming younger kid with sex and luring him to a church parking lot in Texas for sex in her car. Former Friona Police Department officer Delia Ruiz, 31, sexually assaulted two teen boys after grooming them with sex texts for nearly a year in 2020 and 2021. Ruiz, 31, was sentenced Wednesday for the crimes, which saw her seduce and have repeated sex with the kids, aged 15 and 16. The news was announced Thursday by U.S. Attorney for the Northern District. Cops said that she also sent similar messages to a third victim, referred to in court documents as John Doe 3, who Ruiz did not have sex with. She told cops it was because she had not been afforded the opportunity. New York lawmakers reject parents' rights bills. Shock. Really. We wouldn't have expected that, right? The New York State Legislature has failed to pass 3 proposed laws that would have expanded the due process rights of parents in the child welfare system. Can you believe it? Lawmakers worked throughout the weekend, passed a June 2 deadline to send final bills to the governor's desk, but they did not agree on laws that would have barred anonymous calls to the child maltreatment hotline, allowed parents to refuse postpartum drug tests, and strengthened parental rights to legal information. We are deeply disappointed by the legislators' inaction on the Family Miranda Rights Bill, the Informed Consent Bill, and the Anti-Harassment Bill. 3 critical pieces of legislation that would have gone a long way to address the deep harm of the family regulation system, support familial integrity, and honor the due process rights, dignity, and humanity of all New York families, Mack said in an email. Pay attention to this part. Informing parents of their Miranda rights that was denied. Former City Council member Stephen Levin sought to inform parents of their right to have a lawyer present and to deny home entry to city workers who do not have a court order. They have a right. If I got a knock on my door, I don't know what I would do, Levin said last year, describing the need for the change in law. There's a level of fear and intimidation that a parent feels during an investigation, and if they don't know what their rights are, How are they going to assert those rights? So, for the record, you need to study your Constitution and figure that the state is there to build a case against you. Anything you say can and will be used against you. Got that? You have Miranda rights. Study what that means. Also, they lie. You know what that means. Be prepared. So, when a child is put on the Amber Alert, it often involves a parent trying to protect their child. When a foster child goes missing, they don't go on an Amber Alert. They are listed as runaway at any age, which becomes somewhat humorous, except the kid is gone. After 6 months, the state can strike them from the computer, close the case, and they never existed. Gone forever from off the face of the earth. Did you know? Shannon Michelle's video, very upsetting link about what happens when you go to your elected representative and request politely representation regarding missing foster children. Shannon Henderson sent me this from MPLN News, June 8. A juvenile detention center in Rutherford County, Tennessee, that for years illegally jailed children will now be overseen by a 5-member board rather than the county's juvenile court judge. A change designed to bring greater accountability to a long-troubled system. At a meeting earlier this year, the county's mayor said he thought the shift could bring more oversight or transparency. The board members will be appointed by Rutherford County commissioners. Very good. Government investigated government, found crimes committed, and now will observe more carefully. Right? In October, ProPublica published a detailed account in partnership with Nashville Public Radio about Rutherford County's juvenile justice system. Now, this was a story where black children were jailed for a crime that didn't even exist. The story chronicled how the county had illegally arrested and jailed children for years, all under the watch of longtime juvenile court judge Donna Scott Davenport. Last June, the county settled a class action lawsuit, eventually agreeing to pay more than $5 million to hundreds of people who have been arrested or jailed as children. And Davenport has since announced her retirement. Within Tennessee, Rutherford County stood out for years in terms of the percentage of kids it locked up in cases referred to juvenile court. In 2014, for example, the county jailed children in 48% of those cases. The statewide average was 5%. Many children in Rutherford County were placed in solitary confinement under conditions a federal judge called inhumane. These are children, even being put in there for crimes that didn't exist. Meanwhile, the Tennessee Department of Children's Services, which licenses juvenile jails, inspected Rutherford County's jail every year. Not once did it flag an illegal policy under which the jail was incarcerating children. The department refused an interview with this publication. A lot of my stories involve elected or appointed public servants. These people are behaving as tyrannical slave owners. The behavior is, in fact, maladministration. You can get rid of them for that. Look it up as to how. Or see my friend David Jose with the Dave Cares For You YouTube channel. He'll teach you. Shannon Henderson sent me this from Providence Business News, June 29. Jeffrey Hill has served as the Rhode Island Department of Health's Violence and Injury Prevention Coordinator since October 2016. Previously, he was the Youth Suicide Prevention Coordinator for the department for nearly 6 years. Prior to that, he spent 10 years in higher education at colleges in Rhode Island and Pennsylvania, working in student affairs. Seems like such a nice guy. Fall River Reporter, June 7th. Jeffrey Hill, age 46, of Wakefield, Rhode Island, was arrested for possession of child pornography and child erotica prohibited. Hill was identified as the Youth Suicide Prevention Project Manager at the Rhode Island Department of Health. ICAC task force members recently initiated an investigation regarding an individual uploading child pornography to an email server. The internet connection at Hill's home was identified as allegedly being connected to the uploads of child pornography. Earlier today, ICAC task force members executed a court-authorized search warrant and arrest warrant at the Wakefield residence and arrested Hill. Hill had been previously identified as the owner and user of the email being investigated, and an arrest warrant had been signed by a judge charging him with possession of child pornography and child erotica prohibited. He had helped compile the state's adolescent sexual health report. He used the same email for personal and work purposes. He had been among those to make recommendations to the state on how to improve sexual health and care access for minors. What a guy, eh? Who are the people in your neighborhood? Do you know them? Shannon Henderson sent me this from WYFF Channel 4, June 7th, South Carolina. An upstate teacher was arrested over the weekend at a Walmart and charged with exposing himself to 2 women, according to a police report. The report from the Travelers Rest Police Department said John Joseph Gulius, 46, of Greenville, was arrested Sunday morning at the Walmart on Benton Drive, the incident report said. When asked why he did it, police said in the report that Gulius replied, "Just thought I'd kind of be flirty." So what does this guy teach? Police said Gulius told him he is a special education teacher at Pickens County. Shannon sends us a report from the Maryland State Police of Baltimore, Maryland. Troopers arrested a Baltimore man Friday evening after a multi-state investigation developed evidence supporting child pornography and related charges. The suspect is identified as Neil Patrick Gareth, 39, of Baltimore, Maryland. Gareth is charged with 10 counts of possession of child pornography. He is also facing related child pornography charges in Oklahoma. He's being held without bond at the Baltimore City Detention Center. What's he do? Well, he is a city planner for Baltimore City Mayor's Office of Emergency Management. Shannon Henderson sent me this from Mid-Hudson News, June 2nd. The Mamakating Highway Superintendent, who also serves as the Summitville Fire Department Chief, has been charged with felony sex crimes involving a child. Robert Huffcutt, age 55, of Wurtsboro, was arrested by the New York State Police after a several-month-long investigation into the alleged crimes that took place in the past when Huffcutt lived in Orange County. The New York State Police Bureau of Criminal Investigation presented their evidence to an Orange County grand jury who voted to indict Huffcutt on the felonies of predatory sexual assault against a child and coercive sexual conduct against a child. Huffcutt was arrested on May 31, 2022, and arraigned in Orange County Court. He was remanded to the Orange County Jail in lieu of $50,000 cash bail or $150,000 bond. This is an ongoing investigation. Doesn't sound good for the boy, does it? Shannon sent me this from Matt Agarist of the Free Thought Project. I'm reading this important information. You'll understand. June 5, Baltimore, Maryland. When residents of Rockville, Maryland saw Daniel Morozowicz, 38, patrol their neighborhoods, they likely felt protected, but they were not. Morozowicz is a child predator of the worst kind and has since admitted to running a horrifying child sexual abuse material distribution ring. Morozowicz was working at his position in the National Guard, where he was distributing COVID-19 vaccines at Six Flags in Bowie, when feds raided the clinic and arrested him in March 2021. This week, Morozowicz pleaded guilty to possessing and distributing over 12,000 files of child pornography. According to his guilty plea from September 2020 to January 2021, while employed as a Rockville police officer and an Army National Guardsman, Morozowicz received, possessed, and distributed child pornography on the BitTorrent file sharing network. Morozowicz also used multiple electronic devices to download and distribute child pornography involving prepubescent minors and infants. During that time, Morozowicz repeatedly distributed child pornography to undercover law enforcement officers. Oops. On at least 4 instances in 2020, investigators determined that the devices associated with Morozowicz's IP address downloaded and shared child pornographic files on the BitTorrent, including massive compressed files of images and videos. According to the DOJ, much of this material involved horrifying images of infant sexual abuse as well as toddlers. I'm just going to say right here, I'm not sure whether to file this under good news or horrible news. I think good, because the guy is caught. As stated in his guilty plea on March 4, 2021, Morozowicz received a tip that federal law enforcement wished to conduct an in-person interview with him. The next day, on March 5, 2021, law enforcement executed a series of search and seizure warrants on Morozowicz's residence, vehicle, and his person. As a result of the search of Morozowicz's person, law enforcement seized a smartphone, which had been recently factory reset and erased in light of the impending visit from federal law enforcement. Just so you know, guys, you can never erase anything digital. It can't be done. I mean, in case you want to try. He also admitted that he discarded his computer in anticipation of a visit from law enforcement. Morozowicz's actions were viewed as an attempt to impede the investigation and prosecution of his child pornography offenses. You think? Multiple electronic devices were seized in connection the warrants executed at his residence and in his vehicle. A forensic examination of Morozowicz's devices revealed that he possessed over 12,300 depictions of child pornography and erotica, including over 200 depicts involving the sexual abuse of infants and toddlers, and over 90 child pornographic images involving sadomasochistic conduct. Just so you know what they do with the kids after they steal them. In June of 2016, Morozowicz was honored with the department's Officer Achievement Award for his exemplary service. No word on whether or not the Rockville police will be retracting it. Morozowicz now faces a maximum sentence of 20 years in prison, followed by up to a lifetime of supervised release. We shall see. Now for the bad news. As TFTP has reported, a study exposed the startling fact that police officers are arrested about 1,100 times a year, or roughly 3 officers charged every day. Many of these arrests are over unspeakable sex crimes. Police crimes are not uncommon, the study's lead researcher, Philip M. Stinson, concluded. our data directly contradicts some of the prevailing assumptions and the proposition that only a small group of rotten apples perpetrate the vast majority of police crime. Although nearly 60% of the crimes occurred when the officer was technically off duty, Stinson wrote, a significant portion of these so-called off-duty crimes also lies within the context of police work and the perpetrator's role as a police officer, including instances where off-duty officers flash a badge, an official weapon, or otherwise use their power, authority, and the respect afforded to them as a means to commit crime. According to a report from WAPO, in cases involving allegations of sexual abuse, 72% of the officers were fired and more than 80% resulted in convictions, the study found. Now that's some good news. There were 422 reported cases of forcible and statutory rape, 352 cases of forcible fondling, and 94 sodomy cases over the 7 years of the study, which Stinson called larger than expected based on the existing research. The data search turned up 174 examples of male officers arrested in cases of driving while female, in which women drivers were harassed or assaulted. About 82% of those cases ended in convictions. A separate study, as reported by the AP in 2015, found similarly shocking numbers. The probe revealed that 550 officers were decertified for various sexual assaults, including rape. Some were dismissed for sodomy or sexual shakedowns, where victims were forced to perform sexual acts to avoid arrest. A further 440 officers lost their jobs for other sex-related offenses, such as possessing child pornography, being a peeping Tom, sending sexually charged messages to underage teens, or having sex while on duty. About 1/3 of the officers lost their jobs for committing sexual offenses against children. Even more shocking is the fact that every one of these studies indicates that most of the cases go unreported because the victims are scared to report the officers to their own departments. Be careful out there, girls. It is a jungle. This next story comes from Shannon Henderson, and I entitled it, What Happens to an Attorney If They Decide to Really Fight for You in Court? June 3 from the Frank Report. Frank Parlato reports, Connecticut family court crusader Nicola Cunha has been arrested. She was taken into custody by Wallingford, Connecticut police tonight at about 7:20 p.m. She was dining with her husband, Luis Cunha, at Cristo's Restaurant and Bar, when 3 uniformed police officers entered the premises. They arrested and handcuffed Nicola Cunha. Police also arrested Luis Cunha for allegedly interfering with his wife's arrest. Cunha, an attorney for more than 20 years, was disbarred by Connecticut Judge Thomas Mukausher on January 25th. Mukausher decreed Cunha lied to him and committed misconduct when she alleged abusive and prejudicial misconduct of Connecticut Family Court Judge Gerard Adelman against women and mothers. Mukausher noted that Cunha alleged Judge Adelman favored Jewish lawyers, court-appointed therapists, and custody evaluators over non-Jews. Mukausher called her claims empty and malicious. Judge Thomas Mukausher found Cunha in contempt and issued a warrant for her arrest. He didn't like what she said, kicked him off. Cunha has long been a thorn in the side of a well-oiled, tight group of family court practitioners. She maintains this is retaliation. For years, Cunha has called out judges and attorneys for allegedly corrupt, collusive arrangements that seem to award custody to the parent with the most money in high conflict divorce cases. And I hear many of you out there saying, amen, that's true. Did you know that they do that in family court? Oh, yeah. It is a criminal racketeering conspiracy, she alleged. It's a brave attorney. I like her. Unlike other states, Connecticut judges can disbar attorneys for misconduct without a formal hearing process and with no right to confrontation of witnesses. Hey, that's just like how they're taking kids, right? That's how they do it. The Friday night arrest appears timed to coincide with the plan to keep Cunha in custody over the weekend. The court did not provide her with an opportunity to make bail. She will appear in court on Monday. Police released Cunha's husband on $5,000 bail. Detractors have called Cunha anti-Semitic because of her charge that Adelman favors Jews. Cunha claims she is not anti-Semitic and told Frank Report that she was stating what she believes is a fact. Cunha argued that because she alleged Adelman favors Jewish court actors does not mean she is biased against Jews. I am not anti-Semitic, Cunha said. Anyone who knows me knows that I have always vigorously represented litigants regardless of religion, race, color, creed, gender identity, or sexual orientation. Cunha reportedly was taken to York Niantic Correctional Prison to be processed and is likely to spend the weekend there. After arresting Luis Cunha, witnesses overheard police say he put his hands on one of the officers. An eyewitness said he did not touch the officer. So they're going to shaft him with the charge. That's what they like to do. Frank Report learned that video cameras were operational in the restaurant and may show the truth of the allegations. Cunha has argued her arrest warrant is illegal and is retaliation. I was never afforded notice of the alleged wrongdoings that Judge Mukausher falsely accused me of committing. I was never provided the ability to defend the false claims published by Judge Mukausher. Judge Mukausher continues to issue false narratives, she said. She added, I fully respect and support all religions. And that is why an attorney doesn't help you in child protection removals or family court. Shannon Henderson and Catherine Wang Anderson both posted updates on a story I have been reporting on with little 3-year-old Victoria Smith. Law and Crime reported June, and this is kind of a conclusion. Law and Crime reported June 4th, a South Carolina man, Jerry Austin Robinson, who pleaded guilty to child abuse resulting in the death of his 3-year-old foster daughter, was sentenced to 20 years in prison earlier this week. Robinson has long maintained that he never personally abused the toddler, but that he knew his wife, Ariel Robinson, 29, regularly beat her with belts and paddles and that he did nothing to stop the abuse. I told her she'd gone too far this time. I should have stopped it, the defendant told the court during his wife's trial in May of this year. On the day Victoria Robinson died, he said, Ariel Robinson abused the victim for roughly an hour before he came inside. There he told jurors that he found his wife standing over the child saying, You're not done. You don't get to tell me when you're done. After that, Jerry Robinson said, he gave his foster daughter Tylenol, but she got sick and eventually went limp. She told me she loved me, and I said, I love you too. I said, I promised this wouldn't happen again, he said. And it didn't. She died soon thereafter. Victoria was beaten to a pulp. Jurors in Ariel Robinson's case deliberated for less than 2 hours before finding her guilty of homicide by child abuse. She was sentenced to life in prison. The case originally attracted national attention because Ariel Robinson was a contestant on a Food Network game show. Shannon sent me this from Yahoo News, June 5. A Gainesville, Florida attorney facing a total of 22 felony counts related to what he allegedly did to an 8-year-old girl while taking care of her. He's an attorney no more. Michael Metters, 69, remains in St. Johns County Jail, where he's been since his arrest last July. He received no bond on one count of sexual battery on a person under the age of 12 and $345,000 bond on 9 counts of promoting the sexual performance by a child and 12 counts of possession of a sexual performance by a child. Metters has pleaded not guilty. According to an arrest report on July 25, an 8-year-old girl was spending a night under the care of Metters for the evening. The report described Metters as a family friend as well as the family lawyer. The report says Metters recorded himself walking into the bedroom where the child slept and molesting her. The next day, during a call with investigators listening, the report says Metters admitted to molesting the girl with, "I don't know what's the matter with me. I'm so sorry." If you know anything about this case, you can contact St. Johns County Sheriff's Office at 904-824-8304. From the Department of Justice, former Honolulu police officer indicted and arrested for child sex offenses. Honolulu. Mason Jordan, age 31, appeared in federal court in Albuquerque, New Mexico today after his arrest there yesterday on charges of sexual exploitation of a child, coercion and enticement of a minor to engage in prostitution, sex trafficking of a child, and cyberstalking. On May 26, 2022, a Honolulu federal grand jury returned the 8-count indictment against Jordan, which was unsealed after his arrest. According to the indictment and information presented to the court, Jordan, while an officer of the Honolulu Police Department, took sexually explicit photographs of a child in 2017 and used a hidden camera to record sexually explicit videos of that same child on 2 occasions in 2016. Jordan is also alleged to have impersonated that child using social media to recruit other local children to work for him as underage prostitutes in 2020. Jordan allegedly met up with some of those children for commercial sex acts in 2020. Jordan also allegedly sextorted a woman he encountered in connection with his duties as a police officer, using underage photographs he obtained of that woman. If convicted of the charges, Jordan faces a mandatory minimum of 15 years in prison and up to 30 years on 3 counts of sexual exploitation, a mandatory minimum of 10 years and up to life on 2 counts of coercion and enticement and 2 counts of sex trafficking, and up to 5 years in prison for cyberstalking. Shannon sent this story from KTLA News 5, June 3rd. An ROP teacher in the Inland Empire suspected of sending inappropriate text messages to a minor with the intent of committing a sex crime was arrested Thursday, according to authorities. The San Bernardino County Sheriff's Department's Crimes Against Children detail began investigating Elrod, or Lerod, I'm not sure, Jara, on April 22, regarding an inappropriate relationship with a student, according to a Sheriff's Department news release. Jara, a 49-year-old resident of Mentone, was placed on administrative leave from the Colton Redlands Yucaipa Regional Occupational Program, CRY-ROP, amid the investigation. Now, 2 of those places is where I went to school growing up in foster homes. Investigators determined Jara had sent inappropriate text messages to the minor. He was booked and later released on a $50,000 bond. Detectives say there may be additional victims and have released Jara's booking photo. Anyone with information regarding Jara is asked to contact Detective Katie Merrill at 909-387-3600 15. Catherine Wang Anderson posted this from TrueCrimeDaily.com, June 3rd. St. Louis, TCD. A 39-year-old former teacher's aide was sentenced this week to 50 years in prison for raping a young boy and knowingly exposing him to AIDS. Now, when I get done with this one, you're going to think 50 years is not long enough. Court records show a judge handed Deontay Taylor a 45-year sentence for the 3 counts of statutory sodomy, then 5 years for recklessly risking infection of another with HIV when actor is knowingly infected. The St. Louis Post-Dispatch reports Taylor also entered a guilty plea for 2 counts of conspiracy to commit murder. Taylor was convicted April 21. According to the St. Louis County Prosecuting Attorney's Office, Taylor committed statutory sodomy on the 7-year-old boy at Lusher Elementary School. Taylor then reportedly worked with Michael Johnson to find someone to murder his child victim and the boy's mother and grandmother. John White reportedly said Taylor and Johnson offered to pay him $20,000 to commit the crime. According to the St. Louis Post-Dispatch, Johnson is reportedly Taylor's boyfriend, and Taylor met John White, in jail. The article posts complete details of the crime and crimes. The link is here if you wish to read about that. KSDK TV reports John White went to the police after Taylor and Johnson offered him the $20,000 to kill the victim and his family members. White was reportedly in jail at the time for a probation violation. Taylor reportedly said to White in the rec yard of the jail, "I got something I need you to do for me. I want to know if you would take a hit." White shared with the station, "He told me that it was a 10-year-old boy and his mother and grandmother, and I kind of got interested, like, are you serious? You want to hurt a baby?" Taylor reportedly provided White with the victim's address, phone number, social security number, and other personal information. He supposedly ordered White to make it look like an accident, such as carbon monoxide poisoning or a fire while the family was sleeping, and to try to put it on the kid playing with matches. Johnson, Taylor's boyfriend, reportedly worked as a choir director at the time at a Baptist church. Johnson even allegedly offered White diet tips while handing him the money to commit the hit. White told KTRK he went to police because if I didn't do it, he would have gotten somebody else to do it. Shannon sent this from WTVM Channel 9 ABC, June 4, Auburn, Alabama. An Auburn man is behind bars facing multiple child pornography charges. Police arrested 42-year-old Amarjeet Mishra Thursday. Authorities say he was developed as suspect after a March 24 investigation involving the Auburn Police Department and members of the Alabama Internet Crimes Against Children Task Force. Mishra is now charged with 5 counts of possession of child pornography. He was taken to the Lee County Jail and held on a $50,000 bond. He is or was an assistant professor at Auburn University College of Veterinary Medicine, Pathobiology. I'm going to say that education is not the answer to mankind's problems. Money isn't the answer either. Only Jesus will help with the affairs of the heart. A $2.6 billion proposed bankruptcy settlement designed to pay thousands of victims of child sexual abuse has added pressure to an organization beset by years of declining enrollment. And the Scouts and their local councils have been cashing in on their extensive holdings, including properties where some of the abuse took place. It's unclear exactly how much land across the United States belongs to the Boy Scouts of America, partly because it is owned by local Scout councils, But evidence in the bankruptcy trial indicated the local councils own close to 2,000 properties that could be worth between $8 billion and $10 billion, said Timothy Koznoff, an attorney who represents more than 12,000 claimants in the bankruptcy. The proposed bankruptcy settlement with Boy Scouts of America would have its more than 250 councils contribute at least $515 million in cash and property and a $100 million interest-bearing note. Koznoff said the Scouts will need to sell much of their land to contribute to the national settlement, or if it fails, to pay for continuing legal battles. I can't predict how long it will take for all these properties to be liquidated, but I think it's inevitable, he said. Some abuse victims have mixed feelings about the camp's sale. Joe, a victim who did not want his last name used because his family is unaware of his experience, was abused by his scoutmaster starting at the age of 8 in the 1970s at a Connecticut camp that was sold years ago to make way for housing on Candlewood Lake. He's not sure he wants people camping on land where scouts were once abused. My thoughts? When something good or something wonderful has died, we don't circle around it and continue to worship what once was. We simply bury it. Now, I've been following this story for some months, as have Catherine Wang Anderson and Shannon Henderson. This update comes from KSTX, Texas Public Radio, updated June 7th, 22. A new report alleges a treatment facility for victims of sex trafficking may hold some culpability in the death of a girl who stayed there. A young girl identified only as RR, placed at Bastrop-based The Refuge, ran away from a home visit and died in a car accident 2 months later. RR was killed in the automobile accident just 2 months later. The accident occurred in Alvarado, Texas, approximately 180 miles from Bastrop, read the report. Federally appointed monitors charged with overseeing Texas's foster care system and ensuring the state complies with court orders say they received emails alleging the girl planned her escape using a refuge staff member's phone. This is the first time it's been reported a youth in the refuge's care had died. The refuge organization filed a brief with the court early Monday to dispute the allegations. The facility has been under fire since it came out that a staff member named Aisha Green was accused of taking nude photos of girls at the facility for money. Initial reports from DFPS, which the facility is a contractor for, suggest girls had been trafficked. DPS then stated they had found no evidence of trafficking. That has been contested by advocates, and other court monitor reports have suggested a faulty investigation. The new report again suggests that DFPS did not look into the case thoroughly. One girl listed in the incident used a staff member's phone to repost images already saved on her social media accounts. DFPS found that it was without the staff member's knowledge. That was their conclusion. Their CPS initials are DFPS in Texas. The new allegations around RR were raised in a letter to Department of Public Safety Director Steve McCraw from Gina Hinojosa, a state legislator, a vice chair of the House Humane Service Committee. DFPS did not investigate the death or the allegations made in the letter, stating the girl had never been in their custody. The death was viewed as a facilities issue, which would need to be investigated by the Health and Human Service Commission. HHSC licenses facilities used by DFPS. Does that sound very similar to not my jurisdiction? We hear that one so often, don't we? In June 2020, still 16, RR helped 4 adult men ranging in ages from 24 to 36 with robbing a young man. 2 of the men were charged with killing the young man and leaving his body in a cornfield. It was discovered a month later. When she was caught, she was sent by juvenile probation to the refuge in April of last year. In previous reports about the refuge, the girl who had been placed at the facility was worried about having to testify in a murder case. This would be that girl. A few short months later, RR was granted an overnight stay with her paternal grandmother. The girl had allegedly planned to run away with her mother by using a staff member's phone. It seems to me that the girl never disconnected from the mother, regardless of what the state has done with her. It is my understanding that the juvenile was able to plan her escape by allegedly using the assistance of a refuge employee who allowed RR to use the employee's phone to communicate with RR's mother, who ultimately helped her escape, said an excerpt of an email from Representative Hinojosa. The report doesn't say how. The next time she was seen by state officials, she was being trafficked for sex. The Texas Department of Public Safety, DPS, Human Trafficking Unit, located an online sexual advertisement for RR, who appeared to be in the North Texas area. At the time of her death, on the side of the road outside Alvarado, Texas, RR was with her mother, her maternal grandmother, and another girl who had also run away from the refuge 2 weeks prior. The second girl, only described as DD, had run away from the refuge multiple times. The mere fact that two children were able to run from the operation 6 weeks apart and later meet up after both returned to trafficking seems worthy of inquiry, said court monitors. Many of the runaways at the refuge, which is not a lockdown facility, lasted very short periods of time. It's a problematic cycle where runaways are statistically more likely to be trafficked for sex, and trafficked and traumatized kids are more likely to run away. A 2019 study found that 19% of kids in Florida's foster care reported running away at least once. Among 17-year-olds in Iowa, Illinois, and Wisconsin, it was close to half who said they had run away at least one time while in the system. Court monitors said DFPS's response to the issue shows a lack of concern related to allegations and implied gaps in state investigations into the refuge, where runaway events seem to be a systematic issue. Just so you know, running away, they do not look for them. They don't go on the Amber Alert system. They just provide another bed. I'm reading this by Asia Simone Burns, and I've been following this case, so for me, this is good news. When 3-year-old twins Raylan and Peyton Keys wandered off and died after getting trapped in a scorching hot car, investigators in South Georgia blamed their foster mother, charging her and her boyfriend with second-degree murder and cruelty to children. But a lawsuit filed last year blamed their 2019 deaths on the state for missing or ignoring warning signs that, if acted on, could have saved the twins. Last August, Georgia officials settled the suit, agreeing to pay $3 million to the girls' family. The Atlanta Journal-Constitution has learned. The settlement was one of the largest of its kind paid out by the state and stands as a record of failure by the agency charged with protecting roughly 11,900 foster children across Georgia. I want to tell you that $3 million is a drop in the bucket to what the state gets for taking children under Title IV-E and ASPA, so they will recover. The lawsuit filed by Brian and Sky Keys claimed the girls' foster mother, Claudette Foster, failed in nearly every capacity to be an adequate caretaker for their children. However, they placed blame on DHS for allowing her to foster the children at all, saying the agency did not investigate thoroughly enough to determine whether she was capable in that role. The complaint said the Keyses had raised concerns about Foster and claimed that she was unfit to oversee children. It alleged that she was negligent in allowing her boyfriend, Sam Edwards, to care for the children when she wasn't around, and pointed to her misuse of alcohol as another example of her irresponsibility. Months into her role as the twins' foster mother, she was booked into the Liberty County Jail on misdemeanor charges of driving under the influence and weaving over the roadway. She was later released on an $1,800 bond. The twins died less than 2 months later on September 29th. In a DFCS case log, Morningstar staff acknowledged that they were aware of the children spending time with Sam Edwards. Morningstar staff is the contractors that come up with foster care and find homes for DFCS. And they had conducted a background check on him. The document said it wasn't clear how often Edwards was involved with the family, but Foster was told not to stay overnight at his house or to leave the children unsupervised with him. On September 27, a state case manager notified Morningstar of these concerns, but 2 days later, Foster and the children had spent another night at Edwards' home in Hinesville. According to the lawsuit, Foster left the children unsupervised in the morning while she took a nap and had not checked on them nor seen them since the night before. It was over 90 degrees outside that day. At some point, the twins wandered into the home's backyard and climbed into a tan Kia Spectra, trapping themselves inside. Investigators would later pinpoint the time to 10 a.m., using a neighbor's surveillance video that captured the toddler's final steps. Some 3 hours passed before the girls were discovered, motionless, in the car. Foster dialed 911. An EMS first responder came into the residence and asked Miss Foster for the children's birthdays, to which Miss Foster was unable to provide, a police report said. EMS also asked Miss Foster if she could give the proper spelling of their first and last names, to which she stated she was not sure how to spell them, but tried to remember their names the best she could. I'm going to stop there, other than to say Ms. Foster was charged with murder, but we somehow have to get the world to understand that you cannot pay people to have a bond with children who belong to someone else. It was another mother who went through everything required to raise them to the age when the state stole them. Another mother, the real mother, or kinfolk, have a vested interest in caring for a child they have full rights and responsibilities for by the God who gave them. I speak from experience when I say a kid soon discovers they are on their own when they go into foster care. None of them have any protection from what happens next behind the closed doors. I have very good news on a story I reported on last month. The Washington Post reports June 1 that an independent watchdog this week opened a broad investigation into Social Security Inspector General Gail Ennis and her office following a Washington Post report that revealed how an anti-fraud program has imposed massive penalties on disabled and elderly people. The inquiry by the Council of the Inspectors General on Integrity and Efficiency, a group that investigates misconduct allegations against inspectors general, comes as Ennis has been directed by the acting Social Security Commissioner to suspend the program amid mounting political pressure. The magic words here for everyone to pay attention to is political pressure. This is why we get involved with our political system, boys and girls. In a letter, a senior White House official urged a quick response from the chairwoman of the Inspectors General Council, Allison Lerner, who took the unusual step of notifying Congress and the White House that she had opened the probe. On Thursday, congressional staffers will question Ennis's deputies about the program. Given the gravity of the allegations, I strongly encourage the integrity community to work expeditiously, Jason Miller, Deputy Director for Management for the White House Office of Management and Budget, wrote in a letter sent late Monday that also noted concerns about reports of retaliation against whistleblowers who questioned the penalties. They're so mean. It is critical that the American public have full confidence in the important work of the Inspector General community, and that is why it is imperative these allegations be resolved in an appropriate and expeditious manner. So the link I provided will allow you to investigate all of the details of what they have been doing to disabled and elderly people who could have no defense against them. Basically, the ones doing this to a very vulnerable population have been told from the top to knock it off immediately. This is very good news for my friend who works around the clock supplying me with stories for this newscast every month. It looks like it will be keeping Shannon out of the hoosgow, for now anyway. Shannon sent me this from Wet Mountain Tribune, June 1. Looks like Maricopa is still having DA troubles. Jordan Hedberg writes, on June 1, the Colorado Supreme Court suspended the attorney license of the 11th Judicial District Attorney, Linda Stanley, for a failure to complete continuing legal education requirements. Oh, but it goes much further than that. In a statement to KRDO News in Colorado Springs, Stanley stated that the suspension is not a big deal and that law license suspensions are not uncommon. However, it is very rare for attorneys to fail to finish continuing education requirements, as the 45 credit hours can be completed over a 3-year period, generally from home, using approved online courses. The state sent 3 notices with multiple chances to ask for an extension or provide proof for continuing education before the Supreme Court suspended her license. In addition, all cases for the people of the 11th Judicial District are under Stanley's license number as the DA. And it's not clear how the courts will be able to move forward when the prosecutor for the people has a suspended license. I'm sure they'll get around it. That little rule of law thing, that doesn't seem to bother anyone these days. The suspension is part of an ongoing series of failures of Stanley for breaking laws and court orders. Here's where it gets interesting. In 2019, Stanley was censured by the Colorado Supreme Court for failure to alert a client she hired that she'd taken another job with the Department of the Treasury. When the client found out from a third party, Stanley sent the client a bill for work she had not completed. Even though Stanley was working for the Treasury and was not allowed to have a private practice, she threatened her client with a collections notice. For months, Stanley's client petitioned the court to have her removed from their case, with Stanley failing to withdraw herself from the case by filing with the wrong court. In the process, she revealed numerous client confidences and broke 3 state laws. Stanley stated during her election in 2020 that it was common for an attorney to be censured. In fact, less than 1% of all attorneys in the United States have ever been censured. During Stanley's campaign in 2020, she lied on numerous occasions about her resume and background. These lies were exposed by her sister. Oh, don't you know your sister will always rat you off? Sandra Fisher, who wrote a letter to the editor that highlighted Stanley's fabrications, which included stating that her father was a farmer when he was an accountant. In addition, Stanley stated she was a police officer without mentioning that she failed field training at an agency, and that is why she was forced out. Stay tuned, it gets better. Stanley attended most election events with a gun on her hip and holding an AR-15 rifle, stating that she would stand up for the Second Amendment, but never said anything about what she would do as DA. During her election, Stanley admitted that she took an in-kind contribution in billboard advertisements from Jerry Ripley, which was $344.65 over the limit of such a donation. Stanley settled with the state of Colorado, which they stated. The respondent admits that it accepted a contribution in excess of the applicable limit and that it failed to timely report certain contributions and expenditures. The settlement was signed and Stanley paid a $360 fine. Former Custer County Sheriff Shannon Byerly refused to endorse Stanley and instead endorsed the appointed DA, Caitlin Turner. Byerly stated in a letter that he knew working with Stanley to bring justice would be difficult due to past interactions with her. He was joined by 3 other sheriffs and police chiefs who, while all Republicans, refused to endorse Stanley. After taking office, more problems have surfaced. During the failed prosecution of Barry Morphew for the alleged murder of his wife, Stanley repeatedly broke court rules and defied the orders of District Judge Ramsey Lama. At the start of the proceedings, Stanley broke the gag order issued by the court, which prohibits attorneys, parties, or witnesses from talking about the case to the public by speaking about the case in detail for over an hour on the podcast Profiling Evil. In addition, she held a public press conference in direct violation of the court gag order. For months, Stanley botched the Morphew case and ended up hiring outside attorneys to try and help. Last month, she was forced to drop all charges after she failed to properly submit and disclose information to the defense. Judge Lama criticized Stanley in a ruling on April 8, which is very uncommon. Because Stanley failed to disclose important evidence to the defense, the court ruled that 14 of the 16 expert witnesses were excluded from testimony. The court found that Stanley had a pattern of violations. It is clear to this court there is a pattern of discovery violations in this case, attributable to the people. While the court, for the reasons stated, does not find this pattern willful based on the record, the court does find this pattern to be negligent, bordering on reckless. After the Morphew case was dropped last month, Iris Itan, Morphew's defense attorney, publicly stated that I have never seen prosecutorial misconduct this egregious in my entire career, and I've been practicing law 30 years. Once again, this is almost unheard of when an attorney criticizes another publicly. Itan has now pushed for regulation that would hold prosecutors more accountable. Now listen to this part. Nothing ever happens to prosecutors. They can't be sued. They have absolute immunity. They don't get charged with crimes. They don't lose their law licenses. Were you aware of that? Until she has her license reinstated, she cannot practice law. Since taking office, over half the staff have resigned, leaving the remaining staff stretched thin over the 4-county district. They're having fun. Waubonsee County, Kansas, WIBW, a Wamego middle school teacher is facing multiple child sex crime-related charges following his arrest in Waubonsee County. Allendale Sylvester was booked into the Waubonsee County Jail around 8 p.m. on Sunday, May 29, 2022. Sylvester faces 3 charges: unlawful sexual relations, sexual exploitation of a child, and electronic solicitation. The booking report states that the offender, Sylvester, believes the child is between 14 and 16 years of age. Sylvester is listed as a 51-year-old white male. Bond was set at $100,000. According to the Wamego Public Schools website, Sylvester is listed as a science teacher for Wamego Middle School. Superintendent Greg Mann Tuesday confirmed to 13 News that Sylvester has been employed since 2011. So, that's enough good and bad news for the month of June. July is already beginning to pile up, and I'm sure that people in your neighborhood provide us with next month's news. Until then, be careful. Don't take anything for granted. Don't trust the ones in authority. Only trust God.